Man, as if I didn't need another reason to hate passive voice outside of the world of literary fiction. I was doing some research for something else and I came across this. The 2009 Supreme Court decision, Dean versus United States. In 2004, Christopher Dean went to a bank in Rome, Georgia wearing a mask and wielding a gun and proceeded to rob the bank. He was putting money into a sack with his left hand while holding the gun with his right, and the gun accidentally discharged. Fortunately, no one was hurt, the bullet embedded itself in a wall, and witnesses said that Dean was surprised when the gun went off. Dean and an accomplice were later caught and charged. Now, the guy's guilty of the bank robbery. He admitted to it. But the issue was the gun discharge. Federal law mandates a minimum 10-year penalty for discharging a firearm in the commission of a felony, so Dean got 10 years. But here's the thing. There's a really important concept in criminal justice called mens rea. That's some of the fancy schmancy Latin they like to use. Criminal acts require two elements, actus reus and mens rea. Actus reus means the guilty act. In other words, the person commits the wrongful act that's being legislated against. That's kind of important. Mens rea means the guilty mind. In other words, the intent to commit the act. This is also called scienter, from the Latin word for knowingly. Now, some crimes, such as negligence, don't require mens rea. You don't intend to be negligent, but most of them should. Mens rea is a long-hallowed feature of Anglo-American criminal law going back centuries and one of the biggest protector of our rights. Unfortunately, the government has been chipping away at mens rea requirements for a while now. Traditionally, the presumption was that the law required a finding of mens rea in order to convict unless the law expressly said otherwise. But case law has been chipping away at this, most notably the 1943 decision United States versus Dodderwyk, where the president of a drug purchasing company was convicted of criminal acts some of his employees carried out that he had no knowledge of. The Supreme Court said that since he was president, he should have known about it, and so they convicted him. That's not mens rea. You should have known something actually means that you didn't have a guilty mind, and yet they convicted him even though this wasn't a crime of negligence. The court ruled that mens rea is not required whenever the law is intended to result in social betterment, not the punishment of a crime, a decision that's been criticized by legal scholars ever since. It's so vague that unless the law expressly requires mens rea, the courts can arbitrarily worm their way into avoiding the requirement. Now let's get back to Dean. Dean did not mean to discharge his firearm. Witnesses confirmed it. No one denies it. It was accidental. The law is not about the accidental discharge of a firearm. 18 U.S.C. section 924C1A says, any person who, during and in relation to any crime of violence or drug trafficking crime, uses or carries a firearm, or who, in furtherance of any such crime, possesses a firearm, shall, in addition to the punishment provided for such crime of violence or drug trafficking crime, if the firearm is discharged, be sentenced to a term of imprisonment of not less than 10 years. My regular viewers should have caught the passive voice. All this time, I've been saying to ask the question, by whom? But in this case, we know by whom, the person committing the crime. But remember the other point. Passive voice removes all agency from the subject. There is no expression of intent in any sentence using passive voice. So the Supreme Court ruled, the 10-year mandatory minimum applies if a gun is discharged in the course of a violent or drug trafficking crime, whether on purpose or by accident. Except that last part isn't actually in the law, so how do they get the impression that it included an accidental discharge? Here's how. Subsection 3 provides a minimum 10-year sentence if the firearm is discharged. It does not require that the discharge be done knowingly or intentionally or otherwise contain words of limitation. Contrary to Dean's contention, the phrase during and in relation to in the opening paragraph of 924C1A does not modify is discharged, which appears in a separate subsection and in a different voice than the principal paragraph. The only reason they were able to deny the mens rea requirement is because Congress used passive voice when they wrote that clause. And even though it's all part of the same sentence, they specifically said that it was the fact that it was in a different voice that made the difference. Dean's 10-year sentence was upheld. So, completely by accident, without intending to at all, it's now possible to commit a federal crime, not a misdemeanor, not negligence, a serious felony with a minimum 10-year penalty without even meaning to, possibly without even realizing you've done it, all because Congress used passive voice when they wrote the law.